This podcast was produced on the lands of the Gadigal people of the Eora Nation. We pay our respect to elders past and present. In 2020, a major report by the Australian Human Rights Commission quoted that workplace sexual harassment is prevalent and pervasive. It occurs in every industry, in every location, and at every level in Australian workplaces. My name's Yasmine, and this is Law for Community Workers. In this episode, I speak with Katja from the Respect at Work Legal Service to find out more about this huge issue and what you can do as a community worker to help a client or someone you work with who may have experienced sexual harassment or discrimination at work. If you were impacted by any of the issues discussed in this episode, you can call the New South Wales Sexual Violence Helpline on 1800 424 017, or nationally, you can call 1800 RESPECT on 1800 737 732. Thank you so much for joining us on the podcast today, Katja. Could you please introduce yourself and the Respect at Work Legal Service?
Yeah, thanks. Hello, my name is Katja. I'm a solicitor with the Respect at Work Legal Service. I'm located in Lismore, but we are a statewide service with solicitors that service the whole of New South Wales. And we help people with sexual harassment and discrimination issues that have happened at work. We give people free and confidential legal advice and can help with ongoing matters in these areas if people need it. Our team was funded after an inquiry into sexual harassment in 2020 that found that 1 in 3 people in the workforce had experienced sexual harassment in the last 5 years. The inquiry found that the people that were having these issues were mostly young people, Aboriginal people, and people with a disability, and so they're our priority client groups, along with people from multicultural communities. But we can provide advice to people across New South Wales. We are a statewide service.
That's really, really interesting work, and those stats sound quite high. Could you explain what you mean by sexual harassment in the workplace?
Sexual harassment is when someone does or says something that's sexual in nature and you don't like it. And then in the same situation, someone else wouldn't like it either. So the legal definition refers to unwelcome conduct of a sexual nature. So some examples might be sexual jokes, very personal questions, suggestive comments or gestures, or being touched in a way that a person doesn't like. Sometimes it's repeated invitations to go out with someone or another sort of sexual advance. And sadly, sometimes it is sexual assault. It's important to note that the legal definition, so unwelcome sexual conduct, doesn't refer to what the person who's doing the harassment meant by it. So if someone at work makes inappropriate jokes and then says, I'm only joking, or you're too sensitive, it can still be unlawful sexual harassment, even if that person didn't mean anything by it. I do quite a bit of education in schools about these topics, and the students describe feeling uncomfortable about something or someone, and I think that's a good guide. If something at work is making you feel uncomfortable, it's worth getting legal advice to see if it's unlawful sexual harassment and there's something that you can do about it.
Yeah, that's a really interesting thing to point out about the feeling and when it feels uncomfortable, and that, a lot of people are able to identify it as being, it felt uncomfortable, but, I tried to address it. And it is that common situation where people, may turn around in the workplace and say, but it was just a joke, or make excuses for it, or, but they didn't mean this, but they didn't mean that. So I think it's really important to note that intention doesn't matter, and it's about that feeling. What about discrimination? Where does that come into place, or what would that look like?
Yeah, so unlawful discrimination is a little bit more technical in terms of what's not not allowed under the law, it's probably easiest to think of two different aspects. There's a protected characteristic and a protected area. So we ask why the unfair treatment was happening. Was it because of a protected characteristic? And where the unfair treatment happened, was it in a protected area? So, yeah, you're really looking at unfair treatment, why it happened, and where it happened. So, protected characteristics are broadly race, disability, age, and sex. And within sex discrimination, there are some sort of subcategories like gender, gender identity, sexual orientation, carer responsibilities, breastfeeding and pregnancy. So people can't be treated unfairly because of one of those things, their race, disability, age, or sex. But it's also only unlawful if it's happened in a protected area. So those are employment, education, goods and services, which is like when you're in a shop, accessing public places, on public transport, accommodation, which includes sort of rental properties, hotels, and then clubs and associations and sport. So, yeah, sort of looking at why unfair treatment happened and whether it happened in one of those contexts might make it unlawful. I can give you a few examples if that's helpful. So if a 16-year-old boy is followed around Kmart by a security guard, you'd argue that's age discrimination in goods and services. There's nothing about the boy that suggests he would be shoplifting other than the fact that he's young. That could be arguably age discrimination. He's been treated unfairly when he's in the shop. Another example is, and this happens, there's a fight between two men at a pub. The non-Aboriginal man is banned from the pub for 3 months, and the Aboriginal man is banned from the pub for 6 months. So this is unfair treatment. They were both in the fight. They've both caused a problem, but the Aboriginal man has been banned for longer. You would argue that that is racial discrimination, and again, in accessing goods and services when they've been at the pub. In a workplace, we see quite a lot of discrimination in relation to pregnancy. So particularly casual workers, either saying they're intending to get pregnant or in the early stages of their pregnancy are often told there's no more work for them when they say that they're pregnant or trying to get pregnant. So that is sex discrimination in employment and is unlawful.
You often do hear a few misconceptions about discrimination or what people might think discrimination is. And you did say it is has that a bit more of a technical element. What are some misconceptions that you might hear that people have about discrimination or sexual harassment?
Yeah, I mean, it can be complex, so it is really good to get advice if you feel something's unfair. I think there's a feeling that casuals don't have any rights. I mean, casuals, there are some limitations on what casuals can bring complaints about, but they are protected by discrimination laws, and there are also other employment laws that do cover them, and so there often is remedies. So if you're a casual and you get told there's no more work, if you think that that is for a reason that's unlawful, like sex discrimination, it's worth getting advice because you might have some options there. The other thing is something called victimisation. So if you make a complaint about discrimination or sexual harassment and then are treated badly because of that, that's also against the law and applies to all workers. So we have quite a few casual workers, after they've made a sexual harassment complaint, they get less shifts. And that would be unlawful victimisation. So, yeah, again, encouraging people to get advice. Another misconception is that in order to do something about sexual harassment, people need to report it to the police. Sexual harassment can also be a criminal offence, but often it's not. So there isn't a requirement to go to the police, and that shouldn't put people off getting some help about it. So again, the message is for people to get legal advice, and we can talk them through their options, but not to not do something about sexual harassment because you don't want to take it to the police. Get legal advice. We'll talk about it. So another misconception is that you won't be believed because you don't have witnesses. I mean, most sexual harassment victims don't have any witnesses. So please get advice. We can help you present your complaint clearly and advise you anything that you might be able to get to strengthen your complaint. But don't feel that it's not worth doing anything because you haven't got witness or it didn't happen under CCTV footage or something, because they rarely do, and they're still successful. And the final misconception is that people have to go to court to deal with sexual harassment or discrimination matters. That is an end result for these matters if they can't be resolved earlier, but it's actually very rare. There are so many options before court, and the vast majority of complaints can be resolved before having to go there. So when we talk to someone, we always ask what outcome they're after. What do they want out of making a complaint or, standing up for what's happened? And then the options that we discuss with them depend on what they want. So for some people in an employment situation, they want to stay working, and it's about making that safe and having the harassment or discrimination dealt with so they can keep working there. Whereas for other people, they've left, but it's important to them to make sure what happened to them doesn't happen to others. So they want to look at workplace change even though they've left. So they're just some examples. There is a range of things people can do. They can do nothing. They can write or talk to the person who's done the unlawful discrimination or harassment, or their employer or the business who's in charge of that person, or they can make a formal complaint to an outside body, which is like Anti-Discrimination New South Wales or the Human Rights Commission or the Fair Work Commission. So you can see there's lots of options. None of those that I just mentioned involve court yet. So yeah, really good to get legal advice and talk about what they can do. And we can support people through that too. So that's another message to get across, that you don't have to do this on your own. There are free legal services, legal aid. The Aboriginal Legal Service has some funding to help with these matters as well, and community legal centres also provide assistance. So you've got lots of options to help you through this process.
Yeah, fantastic. And a few points that you mentioned that I didn't even know myself. So really, really important to know. And what can someone expect when they do make that step to go and get legal advice? What could they expect from the Respect at Work Legal Service?
So if someone has suffered sexual harassment, they'll be booked in for an appointment with a solicitor without having to tell their story at that intake stage. They might want to send through a written statement, which the solicitor will read before they talk to them. We're really trying to make it a process where the person doesn't have to tell their story and is in a position where they feel comfortable talking about what happened before they have to talk about it. So we allow a longer time for our appointments to allow people time to feel comfortable and tell their story. They can be face-to-face, they can be by Zoom or by phone. We can reschedule if someone just doesn't feel up to it that day. And there's no pressure to have to decide what to do that day. So you can get the advice. Often we will talk through the options. It's a lot to take in. We might send a diagram that helps you sort of look at the different options and think about it. And then we might call back a few days later or a week later just to follow up and see how they're feeling and what they're thinking about it. And that's similar for discrimination, although at intake you might be asked a few more questions about what happened, because we are the Respect at Work Legal Service and we'll help with workplace discrimination, but there are other solicitors in legal aid that help with other types of discrimination. So you might be asked a little bit more at intake just to make sure you're booked with the best team within legal aid to help you. And then once you've had that advice, we can maybe help write the complaint and consider whether you need further assistance beyond that.
And is it a free service?
Yes. So legal aid, the advices are free. If you way down the track had representation from legal aid for a court matter, there might be a contribution payable. But definitely the advice, help with the complaint, help at mediation with Anti-Discrimination or the Human Rights Commission, all those are free. There are some eligibility requirements, but it's really just worth getting advice, and then that'll be all talked through with you at the time.
And do you have any success stories where Respect at Work Legal Service has assisted someone?
Yeah, look, we've been operating a little bit over a year now. We've had some really good outcomes at mediation, with compensation awards ranging from $7,500 to $90,000. But the amount is really dependent on what has happened, but mostly how the person has been affected. So every case is different. You need advice about what might be an appropriate award in your case. But what we've noticed is that often what gives clients the most satisfaction is not the money, but the other sort of outcomes that they can negotiate with the other person. So at mediation, you can be a lot more creative in the outcomes that you want than what a court might order, which is really just compensation. So for one of my clients, the person who was harassing her was sort of in the same area, and she didn't feel comfortable in her local bar. She just thought that he might come in. So part of the agreement was he agreed not to go to that bar, and she was really happy about that. It just meant she could relax now and enjoy socialising there and not have to be watching the door for him coming in, which she had been doing up till then. So yeah, that was a good outcome. Other outcomes that we often include in agreements are training for staff and managers so that the unlawful actions don't happen again. Sometimes there's review of policies or complaint procedures within the organisation, which make it clearer for someone if it happens again, that they know what to do, or sometimes speaking into processes that have been really unhelpful and hard for the person who's suffered the harassment. So redesigning those processes, they're a bit more protective of the person who's suffered the harassment. And even sometimes in the mediation, hearing an acknowledgement from the workplace that the person hasn't been treated well is really important and really validating, and just makes the client just feel much better about whatever outcome comes after that, just because they haven't had that until that situation where they're in mediation together.
This podcast is for community workers. If a community worker is working with someone who may have a sexual harassment or discrimination issue, how can they help that person?
So I think I've said it a few times, but if you only learn one thing from this podcast, it is please to encourage your clients to get legal advice. So we can give free legal advice on these issues. There's no obligation to do anything, but it's really good to know what the options are. I've had some young people who have been discriminated or sexually harassed against, and when we talk, they feel so empowered to know what has happened to them isn't right, and that they have options, that they may never choose to take those options, but they just feel better knowing. It sort of shifts the power, and they know there's something they can do if they choose to. So just encourage your clients to get legal advice. There are some time limits, so complaints to Anti-Discrimination New South Wales and the Human Rights Commission need to be lodged between 1 or 2 years from when the discrimination happened. So please, just be mindful of that, and encourage people to get advice. If someone loses their job, the deadline is 21 days. So it is really important, if someone's been fired, encourage them to get legal advice straight away, because that is a very short and very strict time limit. So I should say the ones about sexual harassment and discrimination are a little bit looser, and there are arguments if someone is out of those time limits, you can still lodge complaints. So don't tell someone it's happened too long ago they shouldn't get advice. Just get advice, and we can talk through those options. Even those 21-day time limits, if someone has been fired, there might be other options with a longer time limit if you're outside those times. So again, just get legal advice. And so, some other things, I suppose, as community workers, you could help a person take notes about what's happened. If they're talking to you about it, they might feel comfortable. So you can make notes, and that would help them when they get legal advice. If that's already been documented, the solicitor doesn't have to go over with that with them again. Maybe suggest non-legal supports, counselling, if they need to go to medical appointments, maybe report to police. You could help facilitate those for them. And maybe help them to think before they come to advice what outcome they want, so they can communicate that to the solicitor. And it'd be really helpful for us if there are any barriers for your clients getting help, that you let legal aid know, because we do want to make sure our services are accessible, and probably clients that you are working with do have barriers for getting legal assistance. So if there is something that we can do better, please contact us and advocate for them, and we'll try and be as flexible as we can to accommodate those needs.
And how does someone make that contact to get in touch with Respect at Work Legal Service?
Yeah, legal aid has so many specialist services, it can get really confusing, but we're really trying to just simplify the way people access our services. So Law Access is now the triage, and you can call Law Access. Their number is 1300 888 529. So if you call Law Access, they will triage you and ask about the legal problem and make sure you get an appointment with the appropriate team. And if that's workplace sexual harassment or discrimination, that'll probably come through to the Respect at Work Legal Service. Unless there's something, the person's in a regional area and wants face-to-face, they might be booked with a local office for them. So just call Law Access and they can assess the client's need and make sure they're booked where they need to be and with the right team for their legal matter.
Fantastic. And I'll put the information about Law Access in the show notes for this episode. And if you go to the Legal Aid website, there's also the option to chat via the web. So there's a web chat option if you do prefer contacting Law Access via web chat. So thank you very much for your time, Katja. Was there anything else that you wanted to add?
No, I don't think so. Just the main message is to get legal advice, never too early to get it. And I suppose share this podcast with other workers so we can share the message.
Thank you so much for your time today. Thank you for tuning in to this special episode of Law for Community Workers. To find out more about what we do, you can go to the Legal Aid website at legalaid.nsw.gov.au. Under Ways to Get Help, you can click Community Legal Education. Don't forget to also subscribe to our e-alert, Law for Community Workers. All the info is in the show notes.